My name is Erwin Chemerinsky. I'm Dean and Professor at the University of California, Berkeley School of Law. On Friday, June 24th, in Dobbs versus Jackson Women's Health, the United States Supreme Court, in a 6-3 decision, overruled Roe versus Wade. This is one of the few times in American history that the Supreme Court has taken away a constitutional right. Few cases, at least in recent history, have attracted as much attention as Dobbs. For conservatives, this is a time to be jubilant. Conservatives for decades have urged the overruling of Roe versus Wade. For progressives, this is a time to feel despondent. This seems to be a court intent on overruling so many liberal precedents. What I want to talk about in this presentation isn't whether the court acted in a desirable or an undesirable manner. What I want to talk about is what it means for constitutional law. I'm going to divide my remarks into 5 parts. I want to start by discussing the path to Roe versus Wade. Then I want to talk about the decision in Roe versus Wade. Third, I'll consider the law of abortion after Roe versus Wade. Fourth, of course, I want to focus on the decision in Dobbs versus Jackson Women's Health Organization. And then finally, I want to conclude by examining what are the implications of Dobbs for abortion, for reproductive rights, and for other constitutional rights. So let me begin by talking about the path to Roe versus Wade. I think the story here has to start in the 1920s. From the 1890s to 1936, the Supreme Court was aggressive in interpreting the word liberty in the Due Process Clause to protect rights to contract as well as other fundamental rights. This was the Lochner era, taking its name from Lochner versus New York in 1905. There, the Supreme Court declared unconstitutional the New York law that limited the number of hours that bakers could work. The Supreme Court said that freedom of contract was a basic right under the liberty of the Due Process Clause, and a law limiting hours that bakers could work infringed freedom of contract. As part of this era, the court also used the liberty of the Due Process Clause to safeguard other rights that were not enumerated in the Constitution as fundamental. In 2 cases in the 1920s, the court interpreted the word liberty in the Due Process Clause to protect the right of parents to control the upbringing of their children. One of these cases was Meyer versus Nebraska. It involved a Nebraska law adopted during World War I that prohibited the teaching of the German language. The United States Supreme Court declared this unconstitutional as infringing the right of parents to control the upbringing of their children. Today, we might think of the law as unconstitutional as infringing freedom of speech. But the Free Speech Clause of the First Amendment hadn't yet been incorporated into the 14th Amendment. It didn't yet apply to state and local governments. Instead, the court in powerful language said, part of the liberty that everyone possesses, right, that parents possess, is to control the upbringing of their children. Just a couple years later, the court applied this in Pierce versus Society of Sisters. It involved an Oregon law that prohibited parochial school education. The Supreme Court declared this unconstitutional. Today, it would likely be declared unconstitutional for infringing free exercise of religion. But the Free Exercise Clause hadn't yet been incorporated and applied to state and local governments. Once more, the Supreme Court spoke of a right of parents to control the upbringing of their children. The court said this includes the right of the parent to send the child to religious schools. The Supreme Court, in the years that followed, continued to use the liberty of the Due Process Clause, the Equal Protection Clause, to safeguard aspects of privacy and autonomy. The court did so even for rights that were not enumerated in the Constitution. Skinner versus Oklahoma was a key case in 1942. Skinner involved an Oklahoma law that imposed involuntary sterilization on those who had been 3 times convicted of a crime involving moral turpitude. The Supreme Court declared this unconstitutional. Justice William Douglas wrote the opinion for the court. He talked about how people have a fundamental right to choose whether to procreate. Now, the court used equal protection here rather than due process, but what's important is that the court found a right, the right to procreate, to be fundamental, even though it wasn't enumerated in the Constitution.